Welcome to the Animal Law Podcast. This is Marianne Sullivan, and today I will be talking to Jessica Rubin, who is the Associate Dean of Experiential Learning and the Director of the Animal Law Clinic at the University of Connecticut School of Law. She and I will be discussing a Connecticut law, which is called Desmond's Law. You know, when you hear those names of and every animal-related law, when they have a name in them, you know some poor animal just suffered horribly and got a law named after them. Anyway, this law allows law students and lawyers to be appointed to assist the court in certain animal cruelty cases in the hopes that these cases, which are often very factually complex, sometimes quite legally complex, and often not well-resourced, to make sure that they're not ignored. There's a lot going on in this interview about the efficacy of laws related to animals, and you will not want to miss it. But before we get to that interview, I have another treat for you. We are also fortunate to have Sherry Kolb and Michael Dorf, who are, of course, both professors at Cornell Law School. And you have heard from them before on the Animal Law Podcast, as well as on the Our Hen House podcast. And they're here for a quick conversation about the Happy the Elephant case brought by the Non-Human Rights Project, which, as you probably know, was recently decided in the Court of Appeals. Very grateful to them. Welcome to the Animal Law Podcast, Sherry and Michael. I'm so excited that you're here because you're here to talk about one of the most exciting things that's happened. Whether good or bad, it's big in a long time in animal law. I'm glad to have your perspective. So welcome.
Thank you.
Thank you.
As I mentioned when I was introducing you, we're talking about, of course, the decision in the New York Court of Appeals, which is the highest court in the state of New York, which is confusing for everybody else in the country. It's not called the Supreme Court. And about Happy the Elephant. And we can't go into a whole analysis of the decisions, including the dissents, which are really important I just really hope that people read them because they're pretty amazing in a lot of ways and really important going forward. But having said that, could you just kind of set the scene with a kind of brief description and reaction to what happened in the Court of Appeals?
Sure. So Happy is an Asian elephant who is over 50 years old. She's spent nearly her entire life in captivity. And for most of that time, she has been in the Bronx Zoo, which is where she is now. The reason she's called Happy is because the people who captured her thought it would be cute to name the various elephants after the seven dwarves and Snow White and the seven dwarves. And the other elephants in that group have since perished. There were a few who didn't get along so much with Happy, which is not surprising. Elephants in captivity are not nearly as gregarious as they are in their natural environment. The Bronx Zoo has said it's going to discontinue its captive elephant program, so it's not clear why they're continuing to hold her, given that the plaintiffs, led by the Non-Human Rights Project, had found an elephant sanctuary where she could live out her days in an environment much more suitable for an elephant. But the Bronx Zoo, despite not going forward with keeping elephants in captivity, is keeping Happy and was therefore resisting this lawsuit that was brought on her behalf. As your listeners probably know, the Non-Human Rights Project, which brings these lawsuits, styles them, as they did in cases involving some chimpanzees, as habeas corpus actions. Habeas corpus is a Latin term for a writ that a court can issue that orders a captor or a guardian or a custodian to release a prisoner. And so if the lawyers were successful in arguing that Happy's captivity was unlawful, then the order would have been to release her into the custody of the elephant sanctuary. There's some discussion in the opinions about whether habeas corpus is appropriate where you're attempting to move somebody from one form of captivity to another, but that's ultimately just beside the point. There are lots of examples involving humans in which a person can bring a habeas corpus action to challenge particular custody in which they're in, even though they're not ultimately going to be freed. They can get a new trial, they can have their death penalty overturned, and so forth. What's unusual about the case, of course, is that habeas corpus has traditionally been employed by human beings. And so in order to get the case before the court, the Non-Human Rights Project argued that Happy should be regarded as a legal person. Now, many people, I think, naturally tend to think that a person is synonymous with a human being, but that's not universally true in the law. Corporations are persons within the meaning of the law. Municipalities can be persons, other governmental units. And so the argument was that if those other non human entities can be persons, certainly Happy, who is a being with all sorts of capacities that make her like humans in various important respects, ought to be treated as a person under the law as well, and was therefore entitled to be released. The ultimate ruling was against the petition. The New York Court of Appeals holds that the writ of habeas corpus is only available to human beings, and their reason is essentially circular. They say, well, it's only ever been granted for human beings in the past, and we're not going to expand that. And they essentially dismiss all of the arguments. But there are two dissents by two of the two different judges who say, you know what? The writ of habeas corpus is flexible and ought to extend to Happy, whose captivity in the Bronx Zoo is really quite cruel, and there's a much better alternative here. There's lots more to say. I'll stop there and maybe turn it over to Sherry to add more details.
Yeah. So what I would say about we did an amicus brief with Professor Lawrence Tribe, and or at least my condition for being part of that was that I didn't want to do what many do in litigation with animals, which is to explain why the elephant is more entitled to freedom than other animals. And so I think the argument that, look, this is an elephant and she can do all these things that very few other animals can do, and therefore she should be freed, that kind of argument strikes me as an unjust argument. That the problem with keeping her in captivity is not that she has a very good long-term memory or that she's extremely intelligent, which she does and is, but the fact that she is sentient and that she is suffering. So our brief, I think, is free of the, elephants are more entitled than other animals, more equal than the other animals sorts of claims, which I think is part of the non-human rights project approach. And they tend to, at least so far, litigate on behalf of very charismatic and highly intelligent mammals and make arguments, and kind of implicitly, I don't think it's explicit, but implicitly when you say, and I had an exchange with Stephen Wise about this once, but he said he's only saying that these qualities that of extra intelligence and autonomy, which I don't think is even a quality, I think it's really something we give to someone. But anyway, said that that's just sufficient for rights, but not necessary. But I think when we argue that some quality is sufficient, we're arguing that it's relevant. And if it's relevant, then its absence is relevant. So I don't really think you can escape the so-called, the animals that matter and the animals that don't matter. And just to be, I'm going to be the negative one, I guess, the bad cop in this conversation. But there's a line, and I really like, in many ways, really like Judge Wilson's and Judge Rivera's dissents. I think they're really powerful. And they talk about how, African Americans and women and children really did not have a status of person in any meaningful sense. And yet courts saw fit to give them justice, even at a time, and it's sort of